Good evening, ladies and gentlemen, dear participants. It is my pleasure to inaugurate today's webinar and to have a dear guest. Today's webinar of the Chartered Institute of Arbitrators hosted by the Cairo Regional Center for International Commercial Arbitration. And it's today the CIArb's Egypt's monthly webinar. It is a great pleasure to host a very distinguished speaker, whom you know, all of you, and he is very dear to all of us. I will still present him, although you know him very, very well. It is Dr. Sherif El-Haggan, or Professor Sherif El-Haggan. Professor Sherif El-Haggan is going to speak today and discuss a very important subject, which is time-barring provisions in construction contracts, which is also a very interesting subject. And we look forward to listen to and to watch his presentation and to ask him questions about this very important topic. So he will be speaking for 1 hour, and then you will have around another hour to ask whatever questions you would like to ask. I understand that today we have broke all records in terms of registered participants. I hope that you will all enjoy certainly his speech. First, before giving the floor to Professor Sherif El-Haggan, I would like to present him. So Professor Sherif El-Haggan has over 40 years of experience in the fields of claims, consultancy, arbitration, and dispute resolution in general, including dispute boards. He is a partner and director of Contract Administration and Arbitration Bureau, which is well known as CAB. Dr. El-Haggan designed the construction law program CLAC, and he considered that this is one of his greatest achievement in his life. The CLAC is very famous. It is the contractual and legal aspects in the construction industry, CLAC, conducted in the Arab Academy for Science and Technology and in the American University in Cairo since 1997. CLAC is a comprehensive 5-course program that achieved great success with participants, including engineers and lawyers. Dr. El-Haggan obtained the fellowship of the Chartered Institute of Arbitrators of London in 1995 and became a CIDR IFC accredited mediator in May 2010 and completed CIDR IFC Train the Trainer program in 2011 and was the DRBF country representative for Egypt from 2012 to 2016. Dr. El-Haggan participated in the ICC FIDIC conferences and conducted FIDIC modules in India and Nigeria and achieved the highest grades in evaluation of speakers in the FIDIC Abu Dhabi conference of 2010. Professor Sherif taught undergraduate and postgraduate courses in the AUC universities, Cairo universities, and Ain Shams University. Dr. El-Haggan obtained the PhD from Sheffield University, England in 1978, then worked for CIArb and Partners in London. In 1982, he was appointed project manager of the Kuwait waterfront project, and in 1982, he joined Dar el-Handasa and performed geotechnical engineering tasks in Turkey, the UK, Saudi Arabia, Algeria, and Qatar, then worked for the Greater Cairo Metro Consultants. These are just some of Professor Sherif El-Haggan's achievements. And now I will give him the floor to enlighten us about the very interesting subject of today about time barring provisions in construction contracts. Dr. Sharif, I will give you 1 hour and 40 minutes and 15 minutes to speak. So you have 75 minutes, and then we will give the floor 45 minutes to ask you questions. You have the floor, Dr. Sharif.
Thank you very much, Dr. Ismail, for the introduction. Thank you for the lecture itself and arranging it, and Yahya for the IT professionality. Thank you very much. I'll just share the screen now. Stop the video. Time provisions in construction contracts. Of course, I will also concentrate on FIDIC forms of contract, being the most famous forms of contract all over the world, with the exception of a few countries, of course. I just thought this morning I'll start with these 2 slides. This is very important point taken from the reference below. Cash flow is like the bloodstream. Very strong. Cash flow is like the bloodstream. So this is an essential matter in construction industry. If the cash flow of the contractor is not based on the conditions of contract and the behavior of the engineer and the contractor, there will be problems. That goes without saying. This slide, taken from the same reference, the question is raised: for whose benefit are claims provisions introduced into construction contracts? Most people will say for the contractor, which is not correct actually. This is the reference book. For whose benefit are claims provisions inserted in construction contracts? The origin was to satisfy 2 essential aims of employers. Quite the opposite of what many of us will believe. It's very logical, by the way, but we don't always think logically. We think it's for the benefit of the contractor. The contractor incurs monies due to risks he owns or due to risks owned by the employer for variations. And until this claim or agreement on variation, price and time schedule is agreed, the contractor is spending from his own pocket, from his own monies. So he gets his money months later, if not years later. One of the main reasons that this claims provisions is considered to be for the benefit of employers is obviously to enable the employer to order variations. And this is a source of problems and disputes. And usually it is the employer who wants the variations to improve his project or to cover the defects of the engineer's design, especially in traditional contracts, like the Red Book, for example. So it is for the benefit of employers. If we consider this point later, we will see the impact of the topic of the lecture on this point. Let's remember it all the time through the 75 minutes. The second point is who has the power to instruct variations? It is the engineer who is the agent of the employer. It's a unilateral variation provision. And here I like to highlight the main difference between a unilateral contract, the irada and farada. I'll just mention a few words in Arabic because many of my colleagues who joined the lecture will follow these specific words, only specific words. The irada munfarida, unilateral contract, it is the person who binds himself. But in this case, it is the party that binds the other party. And the other party has no choice but to fulfill this obligation while agreeing the time schedule or the impact on the time schedule and the price. In other words, the contractor is obliged to perform the variation until the price and the impact on the program is agreed or not agreed, weeks, if not months or years later. So this is a unilateral power which binds the issued by the employer or his agent, and it gives the employer the right to change the scope without obtaining the contractor's consent. Without obtaining the contractor's consent. That's the second major point before we go into our topic. Whenever the employer orders changes through a variation instruction, this will also trigger the contractor's entitlement to extra money and possibly additional time. I'll just switch this bar off because I can't see through it. Now, this is our topic. That's my opinion, and it will be elaborated on during the coming 70 minutes. Since their introduction, for example, in FIDIC 99, time barring provisions have become a major source of disputes. They were promoted because they will resolve disputes. This is a rare situation. They have become a major source of disputes, contradictory dispute board decisions, contradictory arbitration awards and court rulings, even within the same legal system, like we will see, for example, within the common law system. This is a risk that both parties have to take into consideration when negotiating claims or when taking a decision to go to arbitration. They don't know what the arbitrator will rule, whether he will rule, or arbitrators, of course, will rule that they are binding and obligatory and etc., and they bar the right or bar the remedy, or whether they will rule that they are useless and non-existent. Very high risk, by the way, even on employers, not only on contractors. The provisions have hardly ever assisted in timely settlement of claims as promoted and as still promoted until today. Quite the opposite. They became a new source of disputes. The impact of the non-compliance with the provisions has been described in court rulings as harsh, as you will see later, harsh, serious effect, dilemma, cruel, etc. Even by judges who consider that these time barring provisions are applicable. Let's see what the time barring means. And to make a comparison, practical one, let's compare the 4th edition of the Red Book of the FIDIC and the 99 edition, quickly. In the 4th edition, in subclause 53.1, it says, if the contractor intends to claim any additional payment, he shall give notice of his intention. And the word intention, he means that he may not submit the claim letter to the employer within 28 days after the event giving right to the claim has first arisen. That's the procedure. But subclause 53.4 says, if the contractor fails to comply with any of these provisions, his entitlement to payment shall not exceed such amounts as can be verified by the engineer or by arbitrator. Which means that these time barring provisions are not, these notice provisions is not barring. The contractor can prove his entitlement and he will not be barred from obtaining it. This is a major difference between the 4th edition and the 1999 Red Book. So these provisions are not time barring, very obvious in 53.4. So entitlement in the 4th edition and the first 3 editions, of course, and the ICE editions up to the 7th edition, entitlement depends on verification and substantiation. Whatever is proved is entitled to be granted this additional money or monies by the engineer or by an arbitrator. Let's go to the 1999 edition, a major shift here. If the contractor considers himself to be entitled, he shall give notice not later than 28 days, but these new words are inserted. They were not given in the 4th edition. After the contractor became aware or should have become aware of the event or circumstance. Please note this word event, because later on we'll find a different interpretation by many court rulings in the common law system and in the civil law system. 28 days, now the barring entitlement here depends on the procedure. If the contractor does not submit a notice within 28 days, he will lose entitlement to extension of time and to additional monies, and the employer shall be not liable for these claims. Very harsh situation. So the FIDIC Red Book 4th edition provisions and similar provisions are said to bar the remedy, whilst the 99 editions are said to bar the right. And that's what they mean by time barring. Let's go back to 1983, this reference book again. 19 years before FIDIC introduced these time barring provisions, or 17 years. What does this author say? It says, if troubles arise in connection, for example, with earthworks, it may not be immediately apparent to the contractor that he should notify the engineer's representative that some action under clause 12 being the unforeseeable physical conditions of the ICE conditions is warranted. It may well be some time before the contractor realizes that the full implications of the situation and thinks in terms of a claim, and therefore the necessity of a notice. It's obvious here that the intention of what's written here in this reference book is that the notice, the 28 days, do not begin from the event, as is mentioned in the clause, but from when the contractor realizes that there is a need to submit a notice. In such circumstances, the question is asked, when has the event causing the claim happened? And this question is still asked until today. From 83 until 2021, we will see how many court rulings, how many publications have asked this question and give different contradictory answers, even in court rulings. In one sense, it has happened when the excavation in question started, and that's the event, by the way. But in terms of a claim, it cannot be said to have happened until one side or the other, usually the contractor, has become aware of the situation, or could reasonably be expected to have become aware. The same wording, by the way, in the 1999 subclause 20.1, second paragraph. Or could be reasonably expected to have become aware of it as being something possibly warranting a claim. So this second part of the slide means that the period does not start from the event itself, but from becoming aware that a need to enter into a claim is warranted. In this case, يحيى أنا مش عارف أطفي البتاع اللي فوق دي. أقدر أطفيها إزاي؟ بتيجي تاني. One is referring to physical circumstances which are making themselves apparent in the course of the work. For example, more plant, more men, lack of progress, different methods required of construction. Any or all of these can call attention to the fact that there is trouble and should be alerting someone, usually the contractor, to correlate this with the contractor's liability under the contract, and from that to a view that there may be an entitlement to additional payment. That's when the notice should start. Most thinkers, most court readings have ruled according to this thinking or this concept, which has been written in a 1983 book. Based on the clause 53.1 in the 4th edition, for example, which are not time barring, if the contractor neglects to give notice, he can hardly complain if the engineer or later an arbitrator is unable to establish the facts. So these are known to be barring the remedy. So he may lose some of his right because he cannot establish or verify the facts, not because he did not follow a procedure. And this method is better than a sharp cutoff date beyond which claims will not be accepted at all. It is doubtful if such terms can be enforced legally, barring the right. The second point I need to raise is that we should notice that the notice requirement, sorry for the typing error, is part of a whole procedure. We keep saying, is it applicable or not? Is it barring or not? When does the time start? Should we apply it in common law, in civil law, in Sharia law? But we never look at the whole picture. The whole picture, this discussion and this point reminds me actually of this picture. This is a very famous picture about everybody describes the elephant in a different manner depending on which part he touches. Is it only the notes requirement, or is it a complete system? We have, for example, in 99 edition, the role of the engineer to issue a fair determination, fair being the criteria required from judges and arbitrators. How many times have we seen this happening? And I'm talking about the Middle East and similar countries in Africa and Asia. By the way, I've done work in many countries in Asia, Africa. I've hardly seen an engineer issuing a fair determination. But just look at the whole picture by looking at 3 points or 4 points mentioned in the very famous report prepared by Sir Michael Latham, Constructing the Team. Latham reports refers to provisions which he found in the NEC, later named ECC contract, issued by the ICE in England. He says, taking all reasonable steps to avoid changes, a major source of disputes, by the way, and it is a unilateral power to the engineer and the employer. It is the employer who initiates changes. To pre-planned works, where variations do occur, they should be priced in advance. This recommendation has never been followed by any of the FIDIC forms of contract, or for that matter, JCT or other contract forms. If price is not agreed in advance, the contractor will be spending money until they are agreed, until he presents a notice within 28 days, a fully detailed claim within 42 days in the 99 edition, or 84 days, and then they are discussed by the engineer and agreed. We're talking here about 5-6 months later. He spends money for the benefit of the employer for 5-6 months until he gets or does not get whatever he is entitled to. Clearly setting out the period within which interim payments must be made, and failing which they will have an automatic right to compensation involving, that's Sir Michael Latham, payment of interest a sufficiently heavy rate to deter slow payment. Sufficiently heavy rate, which is a problem, by the way, in some Islamic countries. These interest rates, there are different opinions of scholars on that matter. This is the more relevant point, number 11. These numbers are quoted from the report, by the way. Taking all possible steps to avoid conflict, provide for speedy dispute resolution of any conflict that arises by the predetermined impartial adjudicator, referee, expert. This is exactly what we see in the FIDIC 99 edition, subclauses 20.2, 3, and 4, the Dispute Adjudication Board. In most contracts I have seen in the Middle East, many countries in Africa and Asia, these subclauses are deleted. So if the engineer does not issue a fair determination according to 3.5 or 3.7 in 2017 edition, and when the DEB is deleted, where can the contractor go? The only solution is go to arbitration. And this usually happens at the end of the project, or at the end of a reasonable period from the project, 2 years, 3 years or something. So in this case, he incurred monies which we will get after the issuance of the arbitration award, and maybe much longer than that, depending on the recognition and enforcement of the award. What was the purpose of these provisions? The declared purposes, and I quote from publications and from court rulings. In other words, I quote from court rulings, judges' awards in cases, usually in the common law system. These are the purposes given. I ask my colleagues who are following now to review how many times these purposes have been achieved, if at all. The employer may withdraw instructions when the financial consequences become apparent. If it's related to variations, the engineer can make an estimate, is fully capable to make an estimate to enable the employer to make a decision. We don't have to wait for 28 days notice, and 84 days fully detailed claim, and 2-3 months agreement. We're talking about 6 months. I mean, will the employer wait for 6 months until he knows the impact of the variation, for example, to make a decision? Or is it easier and better for the engineer to prepare an estimate to enable the employer to make a decision. Allows the employer to evaluate the claim and take steps to work with the contractor to mitigate the delay. I've never seen this happening, by the way, never. And I've been involved in these matters for the last 41 years, since 1980, actually. To assist in the efficient cash flow management, to assist in the management of budgetary constraints. Budget for who? For the employer, who will learn about the impact on the budget after 4, 5, 6, 7, 8 months, or for the contractor who is now spending money for 4 or 5 months until agreement is reached, or, as I said before, or not reached. To improve administration of contracts and should help to avoid buildup of claims. How many times have we seen arbitration cases where there is 25, 30 claims by the contractor, 5, 6 counter claims by the employer that have not been settled, proving that this is not correct. They never improve administration of contracts. They should, theoretically, but they don't. To successfully manage risks and agree the financial consequences perfectly. Never seen it happening. They are set up to try to resolve them expediently. Expediently, in 6, 7 months, in a year, after referring the matters of dispute to arbitration. Claims procedures are not intended to be adversarial, but are aimed at resolving claims efficiently. Actually, they are used or abused by engineers in most cases, and I say in most cases, not 100%, but in most cases, I'm talking about 90%, 95% of the cases, these provisions are used by engineers to disbar the right of the contractor, not actually to act fairly and issue a determination, a fair determination. Have these things happening? Have these purposes been achieved? Everyone can answer for himself. Now let's move to the common law system, enforceability. I'll just go quickly in these slides, select sentences to see the purpose given in court rulings or in publications by the experts. The purpose is to improve administration of the contract. I haven't seen it happening. To evaluate the claim and take steps to work with the contractor to mitigate the delay. One of the ways of mitigating delays for the engineer to do his job properly, to design the contract, the project properly, in order to avoid the tens, hundreds of variations that are used to correct his errors, design errors. To achieve a more collaborative approach between the contractor and the employer. Another case, court case, they serve a valuable purpose to enable matters to be investigated while they are still concurrent. But why then do we see arbitration cases with lots of disputes that have not been resolved or that have not been mitigated? Sometimes gives the employer the opportunity to withdraw instructions. What instructions? For variations? But why doesn't the engineer make an estimate for this purpose rather than the employer waiting for 3, 4 months according to 99 edition or 7, 8 months 2017 edition in order to make a decision regarding variation orders? Some of them are to correct the design or the errors in the design made by the engineer, by his agent. To resolve, again, the same thing. I just quoted from these papers or from these publications, some court rulings, and then I'll go quickly over these points. The notice doesn't indicate monies. This is an important point. The notice required by the FIDIC or other standard forms of contract is a notice of intention to submit a claim. So it does not really include any monies or extension of time or both. So how can the notice enable the employer to make a decision? And the fully detailed claim will be submitted later. 42 days FIDIC 99, 84 days the FIDIC 2017. 84 days means 3 months. And then the engineer makes an evaluation, asks for more information, more substantiation. How many months are these? 5, 6 months, if settled at all. So is the employer going to wait for 5, 6 months to make a decision on a variation that he requires? or a variation that corrects an error in the design? Is this expedient resolution of claims? I see an ambiguity here. Questions are raised. Should the provisions be ruled to be null and void for lack of proper and fair conduct of the employing engineer in achieving the purposes we have seen in the last few slides? Shouldn't we ask the engineer to prepare an estimate, even certifies accordingly on account for the budget purposes? Third point, design errors will be corrected regardless of their impact on budget and delay. If there is an error in the foundation, for example, it must be corrected. So why should the right here be barred, or the claim be barred for lack of timely notice if we're going to pay the money anyway, going to extend the project anyway? Considering that this design error has been made by the employer's agent, the engineer, not by the contractor. For example, where impact of certain risks cannot be mitigated. If you have unforeseeable physical conditions, or for that matter, unforeseeable weather conditions, you have no choice. You cannot mitigate this. They are imposed on all parties. So why should the right be lost for such circumstances? I'm just giving examples. These provisions, in my opinion, have created chaos. Instead of helping to administer the contract properly, to expediently resolve the claims and the disputes, the opposite has happened in most cases. The questions now, are they operable or not? Are they applicable or not? Do they conflict with public order or public policy? Many of these questions have been raised, creating, as I said, conflicting and contradictory opinions, interpretations, and court rulings. For example, some of the questions raised, the most important ones. What's the point at which the time for service of notice should start? Is it from the occurrence of the event, as the provisions say, expressly say, or is it from the when the contractor realizes he needs to go into or to send the notice for a claim? In other words, realizes that there is an impact of this event. Is it the event or the impact of the event? When does time actually start running? Many questions are raised. These are the most two important points. Let's see what the answers are. Too many contradictory answers. Across the common law jurisdictions, the hardest line is taken in Australia. The hardest line against these time-barring provisions. So in the common law system, Australia takes a hard line and considers that such time bars can be unenforceable as penalties. In New Zealand, the same thing happens. In Hong Kong, they take a completely opposite line, as we will see in a court ruling. And in England, it's a middle of the road solution. So even within the same legal system, we have different interpretations. How can the parties assess the risks regarding these interpretations where court rulings in a same legal system give contradictory answers? English courts recently, so they changed their mind. So they initially had a position, now it's changed. They apply the reasonable recipient test when assessing compliance with the strict contractual requirement. This reasonable recipient approach is shown in the Obrascon case, which we'll see now, which are at odds with the strict approach of the Hong Kong High Court. Hong Kong, Australia, England being common law countries, they have three different positions. Two at extreme, Australia and Hong Kong. In this case, the award was issued in 2014. It deals with the notice requirement for FIDIC 1999, subclause 20.1, specifically paragraphs 1 and 2. Quote, what is often not so clear is the point at which the time for service of notice should start. Doesn't this indicate an ambiguity? The provisions expressly say that from the commencement of the event, but then the judges say that we don't know when it should start. Isn't this similar to an ambiguity, which should be interpreted for the benefit of the contractor, whether it's contra proferentum or civil law? The judge said there is no reason why the clause should be construed strictly against the contractor, given its serious effect. The provisions should be construed together with subclause 8.4. This is a very important point in this court ruling. In subclause 8.4 allows for the notice period to commence running when the project completion is or will be delayed. Is or will be delayed, not when the event commences, but when the contractor realizes that the completion will be delayed. This is obviously allow the contractor to notify delay at a later point than the 28 days mentioned in subclause 20.1. The clause reads, if the contractor considers himself to be entitled. So he must realize that the event caused delay, then he's entitled, then sends a notice. So that's not 28 days, it's 28 days plus something. The court held that the extension of time need not be made prior to the delay actually occurring, not to the event, by the way. i.e., the claim need not necessarily be made as soon as the events occur, but only when the contractor realizes that he needs to enter into a claim or the time program is impacted. Another publication says that the debate in the UK is how to properly assess the time period for the first notifying of an event. The difficult issue is when does that time start running? It should be from the event, as the clause says, but researchers and experts and judges have different opinions. They don't apply the express provision, but they imply a provision. And when you imply a provision, this means that they don't want to apply the provision as is, per se. This is quoted from Redfern and Hunter's International Commission on Arbitration Law and Practice. He says contractual time limits are sometimes drawn so tightly that they may be disregarded by some legal systems on the basis of offending public policy. I have seen contracts in the Arab world and in other countries in Africa and Asia where the period of 28 days has been reduced to 5 days. 5 days. Please think about this 5 days. Who is the engineer who changed the 28 days to 5 days? And what was his purpose? Was it to expediently resolve the claims, or to hope that the contractor will not send the necessary notice and lose his right? Is this engineer acting fairly? Is he acting according to a professional code of ethics? Another research, the dilemma. The dilemma to avoid. So the question now is not whether they resolve the claims expediently, but how to avoid these harsh provisions. Harsh, dilemma, strict time, etc. Again, the time does not begin to run against the contractor until he considers himself to be entitled. How many researchers now? By the way, I've read tens of them. Just Google the words and you will see the answer. But why do we still insist on having these provisions which have not achieved the purposes declared and which have actually caused disputes? Let's pass this, it's the same situation. The conclusion is these cases may assist in overcoming an apparent failure on the part of the contractor to give notice. It depends on the circumstances. And this is very similar to the civil law approach, as we will see later. It is not unusual for parties to indicate through their conduct an intention to waive the requirement for such notice, as also we'll see later in detail, which is known as estoppel. Challenges. So what's the way out of this? That's what publications say. What's the way out of this? That's what judges say. So why do we create something in order to find the way out? For whose benefit? Excessive, unfair, serious consequences for non-compliance. Other common law principles have provided relief, such as the principle of waiver and estoppel. What does this mean? When an employer or engineer is fully aware of the claim event and has engaged in negotiations, communication without raising these time-barring provisions, according to estoppel principles, he loses his right. In other words, by his conduct, the employer may be prevented from relying on the contractor's technical failure of not providing notice to absolve himself of liability. We will see a case at the end of this lecture which has not respected either these estoppel waiver common law principle nor good faith principle of the civil law and created a new situation, a unique decision. This is a real life case, by the way. The principle of Islamic Sharia, they have two concepts. Number one, a just claim never expires. Number two, the contractor should not be precluded from receiving fair and just compensation for its works. So we've seen the common law system now, what the opinion is, and the different and contradictory positions in different countries of the same legal system, and the Sharia. Let's see later what happens with the civil law countries. The concept of preventive acts is based on the universally accepted provision that one is not entitled to his own wrongs. The contractor is subjected to delays and additional cost because of a breach by the employer. For example, error in the design. If you bar the right of the contractor because of a technical notice requirement, then actually the contractor is paying money towards the employer's project, which he will not receive because he is time barred. Is this ethical? Isn't just this unjustly enriching the employer? And what about if the notice requirement is reduced to 5 and 3 days? Should the contractor wake up every day to send notices, 5-6 notices every day, just in case? على سبيل الاحتياط يعني? How can this be called to be proper contract administration? All these slides just prove what has been said already. I'm just showing you how many publications, how many court awards. Hong Kong, despite the fact that the employer caused the delay and the event was known to the employer, at the bottom paragraph, Hong Kong High Court concluded that no valid notice has been issued for a claim of unforeseen ground conditions, and the claim was time barred. Strict application of the provisions, completely different and opposite of the courts in Australia and the middle of the road solution in the English courts. Once again, it's the same idea. Let's see the civil law approach. Most countries in the Middle East are civil law countries like Egypt, Qatar, Kuwait, the United Arab Emirates, Syria, Jordan, etc. Where it appears that a strict interpretation and imposition of the time bars would seriously prejudice the contractor may rely on certain provisions of the civil code to argue a more lenient approach to be adopted. In the civil law approach, in the UAE, for example, there is many court rulings which study the circumstances and either apply the barring provisions strictly or does not. It's not a straightforward interpretation like in the common law system. The civil law jurisdictions have principles that mitigate against non-compliance with notice provisions. For example, there is the good faith obligation. Time bar provision may not be relied upon by an employer in circumstances where he is in breach, design error, and was fully aware that his breach would cause delay to the project. Like, for example, variations for design errors, or even variations without design errors. He knows that he's issuing variations. He wants this change to the project. he can ask the engineer to prepare an estimate for the impact of this variation much faster than agreeing the price and the time impact months later. Article 2461 of the UAE Civil Code and Article 148 of the Egyptian Civil Code states the contract must be performed in accordance with its content and in a manner consistent with the requirements of good faith. For example, if an employer was made aware of the contractor's intention to claim, the employer could be seen as acting in bad faith if he later argues that the notice was not given timely or within the time frame. That's one entry. So you see, it's not a good contract administration. It's looking for ways to avoid the so-called provisions that will help in properly administering the contract. A German court might interpret the contractor's duty, being a civil law country, to give notice not as a condition precedent, but as an obligation of the contractor. Similar actually to the 4th edition of the Red Book. Yani it bars the remedy, but don't bar the right. Unlawful exercise of rights. Also in the UAE and Egypt Civil Code, exercise of a right shall be unlawful if it is disproportionate to the harm suffered by the other party. What will the contractor lose? Money and time spent on the project without receiving these rights. What will the employer lose? Learning about the impact of the variation or whatever the risk owned by the employer a bit late. Which is harsher? I think the answer is obvious. Article 1062C from the UAE law, the exercise of a right shall be unlawful if the interests desired are disproportionate to the harm that will be suffered by others. That's very obvious. So it seems that the position in the civil law countries is much more lenient than in the common law countries, despite the different interpretations in different common law countries. But I don't see why engineers in the civil law countries apply the Hong Kong system. I don't see why. They choose the strictest way of applying them. What was the purpose then? Is the purpose to help in expediently resolving the claims, or in punishing the contractor, or in rewarding the employer? This is very similar to a very important ruling in the Islamic Sharia. It says in Arabic, la darar wa la darar. I've seen so many interpretations here or translations. It says no harm and no reciprocated harm. It is an Islamic principle and a universal rational principle that transcends confessional boundaries. It is wrong that a party who has genuinely suffered a loss might be prevented from bringing a claim in respect of that loss for a technical procedure breach. That's exactly what the first 4 editions of the FIDIC said, and the first 6 editions of the ICE said, and JCC contract. Unjust enrichment. Al-Ifra' bila sabab. An employee may be prevented from relying on a time bar provision to avoid payment, particularly if the only reason is lateness of a contractor's claim. So if he's late by about 5 days, 10 days, 20 days, then he gets work done free of charge. And, or the contractor owns the risk, which is by definition owned by the employer in the contract, in a balanced contract. Courts of the UAE would be reluctant to uphold strict terms of the contract. Civil law country, by the way. Let's remember these slides, 2 slides, when we look at the case towards the end of this presentation, which did not apply civil law principles, nor even common law principles, and created a new precedence, a special precedence, for whatever reason you can conclude. The civil law approach, it is unlawful if it is disproportionate, la darar wa la dirar. The implication, the benefit of any doubt should be given to the contractor. That's very similar, by the way, to the Obrascon case in the English courts. This second paragraph in this slide is almost word by word the same as the judge said in the Obrascon case. and to give the benefit of the doubt to a party means that the judge considered that there is an ambiguity. That's my own conclusion, by the way, that there is an ambiguity in these provisions. These two slides are given to me as a gift from my son, Muhammad Al-Haggan, originally an engineer and now a lawyer. This is a notice requirement regarding a completely different thing in the civil law. And let's see what the cassation court would say, the highest court of the land, the Supreme Court. The notice requirement for a completely different reason, by the way. Article 657 of the Egyptian civil law. In the event a contract is concluded by estimate on the base of unit, and it became apparent, this is very similar, by the way, to these words are similar to remeasure contract, yani in the red book of the FIDIC and all the ICE conditions of contract. And it became apparent that it is necessary to highly exceed the estimation. The contractor must immediately notify the employer. Must. Immediately notify the employer, indicating the expected increase of price. That's the law, by the way. In the event the contractor does not do so, his right to recover the costs in excess to the estimated amount is lost. That's very harsh, but that's the law. But let's see how the cassation court ruled in many cases referred to it. Based on these conditions, challenges 3 cases, just an example, 3 cases. The cassation court, the highest court in the civil law system, ruled that the claimant, the employer in this case, was aware of the possible increase or decrease of quantities, and thus the notice is not a condition precedent to payment. Full stop. I forgot to put a full stop over there. Let's now see, based on this civil law approach and the obvious rulings of the cassation court regarding a notice requirement, let's see this case. This is a case where disputes arose between a contractor and an employer, and the parties agreed, for whatever reason, that to appoint an expert, a sole expert, to give a final and binding opinion. The jurisdiction is civil law, actually Egyptian civil law. Egyptian civil law. Just remember these cassation court rulings. First, I remind you that NEC 3rd edition gives a notice period of 8 weeks, double that of the FIDIC. And I ask FIDIC to please increase the period to 8 weeks, so that if an engineer reduces the period from 8 weeks to 10 days, better than reducing it from 28 days to 5 days. It's still unprofessional, unethical, but better than the 28 days. In this contract, this is a contract where the expert issued his decision. The contract says, replace the 28 days to 7 days. The condition of particular application is abused. 7 days. Take Friday off, they become 6 days. Take the weekend off, they become 5 days. And replace the 42 days in subclause 20 to 28 days. By the way, the 42 days, which are now 84 days in the 2017 edition. Okay, so compare the 84 days to 28 days. The clause 8.4, subclause 8.4, it says replace the second paragraph with the following. If the contractor considers to be entitled to concession of time, the contractor shall give notice to the engineer and present a time impact analysis. For each incident, yes, for each incident. In my opinion, this is an impossible task, by the way, or a very costly task for the contractor, and the engineer must employ a big team to deal with these matters. For every event, to present a time impacts analysis. For each event, what if you have 200 events in the 2-3 year period? So you want a notice within 7 days, actually 6 days, and a time impact for each event. Is this possible to achieve? Is it possible for the contract administrator, contract manager, the engineer to evaluate this and deal with these so many notices and time schedules? Replace present time impact. Next, the time impact analysis shall include a narrative that's within 7 days, describing the cause and effect relationship between the event and the delay, the causal link, that is. يعني الخطأ، العلاقة السببية، الخطأ والضرر. I'm asking, what if it's impossible to establish cause and effect between an event and the delay for consequent events, so many events happening within the same day even sometimes? And what about global claims, concurrent delays, etc.? This can sometimes be impossible to achieve. The rule that cause and effect should be linked for every item of claim presents difficulty. For example, when there has been a succession of claimable events with overlapping and intermingling consequences, which is usually the case, by the way, in most construction contracts, if not all. Let's continue with this contract. That's quoted from the contract. For the avoidance of doubt, the employer solely owns the float. See how many constraints, by the way, for the benefit of the employer. Is the purpose of these provisions actually to resolve the claim amicably and quickly and expediently and to assist with the cash flow? Or is it to help the employer get work done free of charge? The employer solely owns any float. The contractor's claims for extension of time shall not be considered. The contractor waives his right if the time impact analysis is not presented in accordance with this subclause. So not only reducing the notice period from 28 to 7 days, but all these constraints are added. And by the way, this project was completed without any claim resolved by the engineer. So really the purpose was not to resolve them expediently. What did the experts say? Now I call this a miracle, by the way. The experts' analysis. Now let's see an example of the claims. The same building, we have a conflict in the lower ground floor, design error that is, and the ground floor, and the first floor, and the second floor, and the firefighting drawings. And how many? Mechanical services, ceiling and airflow. One building, 1, 2, 3, 4, 5, 6, 7. And the engineer considered that each one of these, his own mistakes, his own negligence, the employer's agent was selected wrongly by the employer. He considered each one of these to be an event which required a 7-day and a time impact analysis to be presented. That's the engineer. But what did the neutral, impartial, and independent experts say? That's what matters now. The expert agrees with the contractor's reasoning. The application of the 7-day time bar was waived by the engineer conduct, estopel. He agrees with the contractor's reasoning. So let's remember, subclause 20.1, there is a time barring provision, which if the contractor does not send the notice within the specified period, which is 7 days in this case, he loses his right. And then the employer negotiates and waives his right if he does not raise these provisions, for example. So the contractor waived his right by not submitting the notice within the time period stated in the contract, and then the employer waives his right. After that, you should continue to study the claim. But what happened? What did the expert say? According, the expert does not find the contractor to have waived his rights. Right. The contractor did not waive his right, but he waived his right. He did not waive, but he waived his right. Let's see. According to the expert, this is quoted from the expert report, by the way, which is final and binding. Accordingly, the expert does not find the contractor to have waived his right for not submitting the notice within the 7 days. The contractor did not waive his right, but the contractor waived his right. the expert considered the 47 days delay, 47 compared to 7, not to 28, in submitting the notice as an unreasonable period under the circumstances of the event for the contractor to alert the employer. To alert the employer for what? For the design errors of the engineer, for the employer's own breach. And that's my question. To alert the employer to do what? To improve the design? To correct the design? This is a breach by the engineer and by the employer. So let's see the miracle here. The contractor waived his right. And the expert sees that because of the employer's conduct or the engineer's conduct, the contractor did not waive his right, but then the contractor waived his right. The contractor did not waive his right. The contractor waived his right. In the same case for the same events. What's the purpose of this, by the way? It's an attempt to not grant the contractor his own monies, which means that the design errors and the time impact prolongation cost will be paid on behalf of the employer by the contractor. This contradiction that the employer waived his right and then the contractor waived his right. So the contractor waived his right twice. Number one, by not submitting the notice within 7 days. Number two, by sending the notice after 47 days. Contradictory opinions or rulings regarding the same provisions. This is the attitude of engineers and experts in a civil law country, which has a completely different view, as we have seen, the common law system. Therefore, the expert agrees with the employer's argument that his head of claim is time barred. Although he said before, this expert, that the employer waived his right. So the contractor's claim is time barred, although the employer waived his right. Time barred for lack of compliance with the notice, which he ruled beforehand that the conduct of the employer is to pill waiver, the employer waived his right. Conclusion, I see no reason why the provisions should be held invalid, in my opinion, under Egyptian and similar laws, civil codes. And in my opinion, it must be complied with, but as part of a whole, not as a standalone point without adding the other points, which is the acting in good faith, which is not reducing the 28 days to 7 days or 5 days, which is asking the engineer and pushing him to issue a fair determination. The way forward, in my opinion, various points to close this meeting or this lecture. And please, don't act like the ostrich. Please, especially employers and engineers, don't act as this. See the facts, see the real life, not the theoretical declarations. Number one, the timely notice is important. I agree, of course. If it's used properly, not abused. Actually, it is essential for contractor's cash flow. It's more important for contractor, by the way, than for the employer. The contractor is the person who suffers if he's paid late. It is in his benefit to send notices. But it's also a duty of the engineer to study the claim expediently, not prolong the resolution of the claim, and pay on account. The decision that the contractor's entitlement is time barred must be designated to the employer. I'm asking FIDIC and other institutions to give this to the employer. To face the reality, he should issue the decision that the time is barred, not the engineer. Don't give a chance to the engineer to abuse this system. Let's ask the employer to do it. The notice is not a tool to penalize the contractor, nor to unjustly enrich the employer. The notice is part of a whole procedure. Remember the elephant story. Thus must not be dealt with in isolation as if it were the whole. FIDIC must stress, for example, in the guide, the blue book, that part 2 must not be abused to reduce the notice period. Actually, I'm asking FIDIC to increase the period to 56 days, similar to the NEC-ECC contract. Experience confirms that the purpose of reducing the period to 5 or even 3 days in some cases is surely not because the employer is very keen to promptly settle the claim and pay monies due to the contractor. Haven't seen it happening. The notice does not contain details of the monetary claim, nor the extension of time. How can they help the employer to make a decision then and take mitigating actions? Where the employer is aware of events, the time barring provisions must not be operable. The fully detailed claim is submitted within 42 days or 84 days in the 2017 edition, and the engineer responds within 42 days, so the total now is 84 days or even longer, 1 to 6 days. I don't think this is like an expedient resolution of the claim. I'm asking the FIDIC and similar forms of contract to make it an obligation on the engineer to make an estimate for the employer to make a decision on whether to proceed or not, and not wait 126 days or longer, by the way. In the meantime, the contractor is spending monies on behalf of the employer, unjustly enriching the employer. On many situations, for example, variation, design errors, the engineer is fully capable to prepare an estimate for cost and or extension of time to enable the employer to make decisions and not wait 126 days or longer to make a decision. These clauses situation where action must be taken, design errors, unforeseen conditions, regarding the situations where the action must be taken. This second word is wrong, by the way, is wrongly typed. I mean, you will have to deal with design errors regardless of the impact of cost and time. You'll have to deal with unforeseen conditions. So these barring provisions should not apply in these situations. The employer must not benefit from the engineer's employer's errors nor breaches. The provision must be ruled to be null and void if reduced below the 56 days or 28 days, and where the DEB clauses are deleted. Most cases in the Arab world, generally African and Asian, I'm not saying that other countries respect these clauses, this is my experience, these clauses are deleted. The employer must fulfill his role as the the engineer must fulfill his role as the first instant arbiter, subclause 3.5 in 1919 edition, and subclause 3.7 in the 2017 edition, and must stop acting the employer's yes man, at least according to a code of ethics or professional code of ethics. To conclude, I'm recommending to contractors to avoid having to put forward complex legal arguments which may be accepted or not, as we have seen in this expert's opinion, contradictory interpretation of the contract. The prudent contractor should always take care to comply with the time scale set out in the subclause and submit the required notice within the prescribed period of 28 days, 7 days, 3 days. I mean, you will have to follow, unfortunately, the just in case attitude. In other words, wake up every morning, send 5, 6 notices, let's see how engineers will deal with that. That's the only way to convince FIDIC and other institutions to change this attitude of time barring provisions. In 2010, this last slide, in a presentation I made in London with the FIDIC Contract Users Conference, that was my conclusion regarding the time barring provisions. I said I strongly recommend the provision to be replaced with the subclause 53.4 of the Red Book 4th edition, i.e. to bar the remedy and not bar the right. Thank you very much indeed. شكرا دكتور اسماعيل.
Thank you very much, Professor Sharif, for this very rich presentation, which has covered several types of FIDIC contracts, several jurisprudence from several legal systems, even Sharia. And I see a lot of questions coming from the floor. So there is first a logistical question. Is this presentation going to be sent to us? So of course, this is the author's right. It depends of Dr. Sharif's willingness to send the presentation to the audience. It depends. It's really your choice.
Please send it to all.
Very good.
I beg you to do that.
Excellent.
Please publish it on any media you have, Facebook, site of the. Please send it all, and I will get the file from Yahya, Engineer Yahya, and I'll publish it also on LinkedIn and everywhere. Send it to whoever wants to see it.
Very good. Another request, we just need the PDF of this presentation. Okay, that's fine. Another question, what should the contractors do to guarantee their rights to extend time and avoid losses?
That was the subject matter of the last slide, by the way. Send notices within the period stated in the contract, and don't depend on legal arguments. You can use these arguments only if you fail to do that. But that's not a right solution. That's not a balanced solution. That's not a fair solution. But you have no choice now until institutions change their mind, until engineers change their attitudes.
Okay, this was a question from Mr. Hussein El-Sobki. Now another question from Mr. Mazen Khalifa. In the case of having a variation due to a major design mistake, in the case of having a variation due to a major design mistake, most of the time the client is trying to have it fixed by the contractor at his cost, at his own cost, simply because the consultant fees will not cover the cost of the variation. However, we all know that this is not fair. What do you advise to avoid that?
If the contract is traditional, for example, in the Red Book, then the contractor should not correct the design. Otherwise, you will not only carry the impact of the time and cost, you will also carry a liability for this design. And this is very dangerous. The contractor in traditional contracts is not a designer. The employer should correct the design or the engineer, and the contractor not only for extension of time and additional cost, but for design liability. You should not change the design or correct the design. It's up to the designer, which is the engineer, to do that.
Some scholars, another question from Mr. Omar Abdel Qadir. Some scholars in civil law jurisdictions state that such conditions like the time barring are prior agreement. And he's writing in Arabic, اتفاق على الإعفاء من المسؤولية العقدية, or an agreement for exemption from liability or contractual liability, وهو ما يسمح به القانون المدني المصري, and this is permitted by Egyptian civil law. What's your opinion about this argument? البعض الآخر يدفع بأن هذا الشرط يعتبر تنازل عن الحق قبل نشوئه وبالتالي باطل. So some other would invoke that this condition is a waiver of right prior to its creation, the creation of this right. And so it's null and void. What's your opinion about that?
Well, in addition to what I said about civil law jurisdictions and civil law cases and the cassation court rulings, there are the notice for additional quantities or additional prices, which rule that because the employer is aware of the event, then the condition is not a condition precedent. But this is the danger which I hinted at. Thank you for this question, Dr. Ismail. I've seen arbitration awards in Egypt. When I say in Egypt, I mean the same civil law, where they took completely different attitudes. In one case, they considered this barring provision to be in contradiction with public policy, and so they did not at all enforce them, as if they are non-existent. and in some cases they apply them strictly, which means that, it's a very important question, which means that when deciding to negotiate between the contractor and the employer, I'll give an example. Suppose there is 20 claims by the contractor. To simplify it, each one is £1 million each. And the employer is a good employer, good faith, wants to settle the disputes. 13 of these claims were submitted within the time specified in the contract. 7 have not been. And the employer was ready to pay £13 million, but he told the contractor, I cannot really entertain your 7 claims where you didn't send the notice beyond the time specified in the contract. Let's say the contractor went to arbitration, and we only know the result after the arbitration award is issued. And one arbitration tribunal did not apply the condition precedent provisions, and hence ruled for the contractor the £7 million. Had the contractor known, had the employer, known that this would be the result, he would have negotiated in good faith as he did with the 13 claims. Or the other alternative is the contractor knows he will lose the case, so he accepts the £13 million, and he doesn't know that maybe the tribunal would rule for him for the £7 million. Both parties have a big problem, actually 100% risk in assessing the situation. Do I go to arbitration or do I not? If it's the contractor. If it's the employer, do I negotiate the 20 claims or only the 13? It's not only the contractor, by the way, it's the employer also who has a dilemma regarding the interpretation of these. He doesn't know the result until the award is issued, and the awards have been contradictory, by the way, even in the same country, in the same civil law. That's the danger of these provisions. They are very dangerous.
Thank you very much. Another question from Mr. Mazen Khalifa. So in the case of having a variation due, this one has been answered. Does ignoring the time-barring provisions, this is a question from Mr. Karim Zahran, does ignoring the time-barring provisions when ruling for a dispute mean that we are ignoring the pacta sunt servanda principle, العقد شريعة المتعاقدين?
No, if you ignore a provision, for example, I just give an example to indicate the question. If you ignore a provision that's in contradiction with public policy, then العقد is not شريعة المتعاقدين. The contract is the law of the parties, but when it's not in conflict with public policy. I'm not saying that provisions are in conflict, by the way, but I'm saying that actually we have seen the different positions in 3 countries of common law system, which tend to want to apply the contract as is. And I've seen the position in the UAE and Egypt. And we have seen the position regarding even the notice requirement by Article 5657, which is obvious, expressly provided for, non-ambiguous in the civil law. But the Cassation Court ruled that despite this notice, the employer was aware, so the notice is not a condition precedent. So not everything in the contract shall be applied strictly per se. That's again the risk, by the way. I said that in the beginning. That's the risk of this matter. You don't know what the result will be of the court ruling in a civil law country, or even in a common law country, or an arbitration award. So none of them, neither party knows about that. It's not only for the benefit of the contractor or employer. When deciding to refer matters to court or to arbitration, you don't know the result, of course, unless it's too late when the award is issued.
Okay, thank you, Dr. Sharif. Another question from Muhammad al-Bishri. I understand that such time bar provisions can only be used to make sure that contractor shall only be entitled to the necessary costs exerted as he had issued on-time notice and follow the instructions and mitigations directions that could have been done by employer had he notified on time, right?
Yeah, if the contractor prepares a proper claim and he's an expert or used an expert to prepare the claim, he's entitled to cost and extension of time as proven, depending, of course, on the evaluation of the engineer, or later as on the dispute board or on the arbitrator. So the onus of proof lies with the contractor. That's obvious to me. Did I answer the question, Hamad al-Bishri?
Yes, I believe so. Another question from Mr. Hani Shaheen. Are employers, engineers expected to allow contractors to raise claims about conflicts in their contract documents that they have willingly signed 2 months later? What if the project's whole duration is 4 months? Are they supposed to bear the consequences of contractors' failure to properly study the project documents during tender? Are they supposed to allow contractors to profit from manipulating their prices during tender and then trying to make up for their manipulation by by cherry picking conflicts in the design whenever they want to? So this is, as you have seen, a question.
Not one question.
but you know, it's taking, you know, the point of view of the employer here.
Of course.
What the employer fears from
it's obvious.
Any abuse by the contractor.
He's talking, for example, about the review of the design during the tender period. Who said the review is to replace the role of the designer in doing his work? Said who? Give me one article or one clause in the FIDIC contracts, apart from design build, of course, which is a completely different nature, that the contractor is responsible for design. If the contract is traditional, then the engineer does the design. And if there is only conflict, it will be interpreted accordingly. الشك في مصلحة المدين, or even contra preferentum, against the person who prepared the contract. These are rules that are known in the civil law and the common law system. So why do you want the contractor to be a better designer than the designer of the project? Who says that the traditional contract, which is build only, that the contractor should review the design to correct the engineer's design? Why should the engineer try to offload his errors, his lack of quality, his inability on the contractor who is not a design build contractor? I'm asking my colleague to answer these questions for himself, because the contractor does not abuse the situation. It is the employer. He employs an incompetent engineer and wants to the contractor to improve and to correct the errors of this non-competent engineer. This is totally unethical to me and totally illegal, and any conflict in the contract shall be construed. That's a rule in the civil law and in the common law. In both cases, the rule will be interpreted for the benefit of contractor, the debtor, or against the person who prepared the contract. So in this case, it will be interpreted against the contract, whether you use the civil law approach or the common law approach.
Another question from Mr. Omar Abdel Qadir. The situation is confusing as well for engineers. Think about an engineer who didn't prepare the contract by himself, and the parties agreed to such conditions and clearly agreed in the contract that failure to submit the notice shall bar the contractor's rights. What should you do, and how should you act as an engineer?
The engineer does not prepare the contract, or who prepares the contract then? Is it the contractor or the employer, or use a standard form? If it's a standard form, I've dealt with that, by the way, in the past 70 minutes. Time barring are subject to different interpretations in common law and civil law countries, as I said, and they are more lenient in civil law countries because of various points I mentioned. And you don't know whether the time will be ruled to be barring an arbitration case or in the court case, even in a court of cassation. So this is the risk of having these barring provisions applied strictly, especially when the engineer or employer reduces the period from the 28, 56 days to 5 or 4 or 3 days. I need to add something, Dr. Ismail.
Yes.
I'm asking the employers to use competent engineers, not to absorb them from the errors. By doing that, the consulting engineering business is collapsing in the Arab world and similar countries. If you punish me, the contractor, for your own engineers' errors and incompetencies, you're actually causing the consulting engineering industry to fall. It's falling down. Engineers' works or bad quality is always uploaded to the contractor. He should have reviewed the design. Who says that the review of design is part of my task during the tender period? Or isn't it the engineer's job to review his own design, to create a mechanism within his own company or office to review his design? And then if we ask the employer, sorry, the contractor, to bear the consequences of bad errors or errors in the design, isn't this transferring the red book into a yellow book? Isn't this in essence transferring a traditional contract into a design build contract and removing the difference between these two contracts in Egypt or other similar countries? The contractor is not responsible for the design. Actually, even with the senior liability, there are cassation court rulings where the rulings were against consulting engineers, either structural engineers or geotechnical engineers, not against the contractor. I'm saying cassation court rulings, and my colleagues who attended CLAC are aware of this, and they have copies of them.
Okay.
There is no benefit in asking the contractor to discover the errors and the mistakes of an incompetent engineer. There is no benefit at all.
Okay. Sorry, there are a lot of questions. I'm lost in the number of questions sent. Yeah. Ahmed Hussein. Okay. When, sorry, sorry, I'm going to find the question. Mr. Mahmoud Al-Saadani, kindly, do you see that in the near future, the employers and the engineers will adopt this point of view? And if not, will the arbitrators and the court interpret it as per your presentation?
I cannot force people to follow my presentation, but my presentation did not give one point of view, by the way. I gave all the points of view and the contradictory ones, and to prove that they are contradictory. Interpretation is contradictory even within the legal system, the same legal system, as you have seen the attitude of the courts in England. A Brascon case is very important, by the way, and in Australia, which take a stand against these provisions, and in Hong Kong, which adhere to them strictly. I'm talking about the same legal system, common law system. So how can I force people to do that? All I can do is to show these mistakes, to show these problems, to show these risks, and ask engineers first, dispute board members and arbitrators to take a stand which will be balanced. But I cannot really force the world to follow my opinion. Noting that I did not give one opinion, by the way. I did not really speak on behalf of the employer or the contractor or the engineer. I showed all the possible opinions in the literature and in the different legal systems. I mean, the three main legal systems, the common law, civil law, and Sharia principles.
Here, there is another question from Mr. M.M. Mushtaba Muhammad. What is the meaning of bar, the remedy, not the right? Can we have an example?
Yes. For example, in the fourth edition of the Red Book, subclause 53.1 and 53.4, it requires the contractor to submit a notice within 28 days. But then in subclause 53.4, it says the contractor does not lose right for non-compliance. This they call bars the remedy. What does it mean? It means, for example, if the contractor is, let's say, incurred unforeseeable physical conditions, let's say rock, which was not expected, and he was late in sending a notice to the engineer, and the engineer could not verify his right. He only verified part of his right. Let's say he excavated 10,000 cubic meters of rock, but because he was late, he punished himself, in other words. And because his right depends on the proof and substantiation, not on the procedure, the engineer managed to verify 7,000 cubic meters of rock only. So he'll be entitled to the cost and the time impact regarding the 7,000. This is barring the right. Of course, he may lose all his right if he's very late, or he can get all his right. It depends on the proof substantiation. So subclause 53.1, 53.4 are good examples, and they are available to everybody. I've shown them in my presentation. They will see the PDF file. That's barring the right. But in subclause 20.1 of the 99 Red Book, second paragraph, it says if the notice is not sent, the contractor loses entitlement. So this is called barring. Sorry, I made a mistake. With this fourth edition of the FIDIC, 53.1, 53.4, the barring is regarding the remedy. The remedy may be reduced depending on proof and substantiation. In the 99 edition, the right is barred, regardless of proof. So if the contractor can prove his entitlement, he loses entitlement because of not following the procedure. So in the fourth edition, it's barring the remedy, partly or totally. In the 99, it's barring the right because he loses entitlement completely because of a procedural issue, a technical issue. Is it clear to the person who asked the question? So I made a mistake in my answer in the beginning.
No, but I believe it's very clear. Thank you. And now another question. Yes, the contractor has accepted and put his price on such provisions. Why?
The contractor put price on such provisions? On what? On time barring provisions?
Yes.
Did he know that he will not send notices intentionally, and he paid and calculated that in his money and time schedule? Did he know that? Did he know that the engineer will interpret the clause harshly? This is an impossible risk to. And despite that, by the way, I asked my colleague to see why do we have different court rulings in the common law system, in the civil law system, and why would you have different interpretations regarding these rulings? So if we have different awards by courts and by arbitrators, experienced arbitrators, then how do you expect the contractor to be able to assess this risk? I'm calling for not reducing the notice below the 28 days. I'm asking FIDIC to increase it to the same period in the NEC, ECC. By the way, the NEC contract was the one to be recommended by Sir Michael Latham in his construction design. He said this is the best contract to be used, in his opinion and his committee. So let's increase the period to 56 days. Let's give the contractor time to appreciate that there is a need to enter into a claim. By the way, if the contractor literally follows the notice period, let's imagine a caricature. The contractor sends, especially if the period is reduced to 5 or 7 days, he sends notices just in case. على سبيل الاحتياط in Arabic يعني. So he will send, for example, 200 notices of claims. But then he finds that he's not entitled, or the entitlement is so small, it does not warrant a claim or a dispute. Fully detailed claims, maybe 20 cases or 50 cases. So what's the point in increasing the notice of claims? On the concept or the philosophy of just in case. Is this good management of contracts, to manage contracts on a just in case basis? I don't think so.
A question from Mr. Ahmed El-Far. So this is it's about the characterization of these time bar provisions. So based on your experience, can the non-compliant party successfully argue that a notice provision that seeks to extinguish the party's otherwise valid claims should be viewed as a prescription period? As you know, pursuant to many laws in the MENA region, any agreement to extend or reduce a prescription period is void. Accordingly, if viewed as a prescription period, contractual provisions that bar claims could be argued to contravene a mandatory provision and therefore unenforceable. I think it's a lawyer. This is a question from a lawyer.
Yeah, never mind. I mean, he has seen in the presentation that the Embarascon case, for example, they said completely different answer to him. That's a court ruling, by the way, not my opinion, or not an opinion of a scholar. We have seen in the Cassation Court, despite the express provision in Article 657, that it ruled that this is not a condition precedent simply because the employer was aware. Is the employer aware that he will issue a variation order to improve his design or to correct the design? He is aware. So the Cassation Court, highest court in Egypt, not the Sharif's opinion or anybody's opinion, considered that the notice requirement of the law is not a condition precedent. That's an answer to a lawyer, by the way.
Very good. Another question from Mr. Kamal Omran. Why the design is a contractor's responsibility in civil law?
It is not. This is a big mistake. In administrative contracts, unfortunately, laws 89, 182, etc., and law number 9, 1983, it says that the contractor is responsible for the design as if he prepared the design. This is ridiculous. As if he's prepared. So this sentence means that the contractor is responsible for the design even if he did not prepare it. In other words, we are equalizing now the red book and the yellow book. This I've never seen this in the world, by the way, except an Egyptian invention, unfortunately I say that, which I called many times in the CRC conferences next to Dr. Abu Al-Ainain 25 years ago. Let's remove these ridiculous clauses because it encourages the engineer to be negligent in his design. And because of other causes, by the way, because it creates a room for corruption. I'll give an example. We have a design by the engineer employed or appointed by the employer. And then the contractor says, for example, the design of foundation is unsafe. I want to use piles instead of footings. The employer in this case has no choice except to agree to the piles because he's worried that the building will collapse. Assuming that the piles are not necessary, then we open the door by these clauses, by these articles, by these provisions in Law 182, 89, Law number 9, we open the door for corruption and for different opinions of engineers, genuine or not. Now, if we say that this engineer of the geotechnical engineer of the contractor said we need piles, and I have a case, by the way, I have a case at hand now. The employer says footings or a raft, and the contractor's engineer, foundation engineer, say use a pile. How can you force him to use a footing if he tells you that I cannot use a footing because my engineer, specialized engineer, consulting engineer says if you use a footing, the building will collapse. So you open a door for variation orders or for corruption. Every person should be responsible for his own work. That's in Law 182, by the way. I'm seeing administrative contracts, but in civil contracts, the civil law does not consider the contractor responsible for design. I just said that there is a cassation court rulings which rule that the consulting engineer, in this case the foundation engineer, was responsible for the collapse of the building and not the contractor. So who says that in Egyptian law the contractor is held responsible for design? He's not. In civil law, he's not. And I'm referring to cassation court rulings, not the opinion of Ansan Houri and all authors on this matter. There is a big misunderstanding. The civil law does not hold the contractor. He did not prepare the design responsible for this design. In other words, In the Red Book, the contractor is not responsible for the design, and this is a position of the civil law.
Another question from Mr. Mohammed Abdelaziz. As usual, the employer add that on the, so the employer makes a change in the particular conditions, whereby the contractor would be fully liable for the design once the contractor is awarded the project and signs the contract. And then he is asking how we could how can we prevent such modification because it changes the contract actually from the Red Book to another, such as the Yellow or the Silver Book? Yes. How can we do about this?
You can only negotiate if you study the contract. And I don't think this is, by the way, sorry, I'm repeating, this is a disaster in Egypt created by this idea of the 182 law and etc. This is a disaster which engineers abuse to not carry responsibility. I'm declaring this is a disaster. And I don't see how an engineer is professional if he does work, gets paid for it, and then puts a line in the contract that the contractor is responsible for his work. The engineer who adds provisions in the contract for traditional contracts where the contractor carries responsibility, this engineer should not become an engineer. He should be removed from consulting engineering firms. But unfortunately, this is a tradition, totally unethical, totally disastrous to the construction industry. You cannot do anything about it. If you agree to this contract, you have accepted the responsibility, because it's not against public policy for you to accept such responsibility. I'm asking engineers to respect themselves, and for employers not to employ engineers who get rid of their reliability for work they have done and been paid for by the employer. I wonder how employers accept that an engineer who was employed by him, who did a design and was paid for it, how can he accept that he removes this responsibility from his shoulders and put it on the contractor? This is not a good engineer. This engineer is not competent, and many are like this. Most are like this. And the main reason comes from the laws number 983, 1988, 89, and law 182. This is a disaster.
Another question from Naizak Abdullah. What is the point of getting the right and losing the remedy? FIDIC 1987.
I don't understand the question. The fourth edition. Getting the right and losing the remedy. There's no point. That's what the contract says. It's not my opinion. If you send the notice late, and because if you sent it late, I'm talking to the contractor now, the engineer or later arbitrator cannot verify your right, then you can be entitled to less than what you're entitled to. So this tempts you to send the notice within the period. So you may lose your right, all of it, part of it, or none of it. Because as I said, your entitlement depends on the proof. But in the 99, entitlement depends on a procedure, a simple procedure, which is wrong in my opinion. Especially when the period is reduced to ridiculous 3 or 5 days.
Okay, Dr. Abdel Wahab Tahsin, there is a need to identify the liability issue assignment between the civil law provisions versus the famous for sentence promoted usually by the consultant and usually plotted in the drawings of general notes that the contractor is responsible for the design as if it was issued from his side. We have answered this question. Yes. Who is the owner and domain of the liability for both the consultant and the contractor performing company? I think we have answered this question.
Dr. Ismail, just a funny story. There was a program for state council judges, 70 of them, and discussed, Dr. Abu Al-Ainain, Allah yarhamu, Dr. Muhammad Badran and myself, and Dr. Badran said at that time, being administration law professor, he said, we need this because employers use not very competent engineers. But I said, but also the contractor will use a not very competent engineers. And the reason was that you remove the liability of the engineer to the contractor, who will use another engineer who is not competent as well. It's a vicious circle. We should really break this vicious circle. That was the CRC, by the way, long ago.
Yes. May his soul rest in peace, Dr. Abu Al-Ainain, of course, and Professor Badran, of course. Another question from Mr. Amir Abdullah Fouda. I would humbly just consider the employer position in cases of applying variation order procedure prior to the issuance of the instruction. Then the contractor keeps sending useless estimates in terms of cost and time to protect the process in order to cover his own concurrent delays, causing volantini non fit injura. So I would like to hear Dr. Sharif's opinion in this opposite scenario.
It's simple, in my opinion. If the contractor sends non-warranted estimates, assuming that this is the situation, the engineer is still empowered under subclause 3.5 in the 99 edition, 3.7 in 2017 edition, to endeavor to reach agreement, i.e. act as a mediator. If it doesn't work, he should issue a fair determination. And therefore, the delay has stopped because he issued a fair determination. It's up to the contractor to go to DEB or to arbitration. Then he's not really delaying the project. That's if the engineer performs his duty to issue a fair determination. Then time is not delayed anymore.
Okay, another question about Qatar. So from Ariana Lucero, based on your experience, how are the time bar provisions being interpreted, applied by the courts in Qatar?
Qatar is a civil law country, and they will be applied on the same basis I indicated for UAE and Egyptian civil code. In other words, they may be applied as is, or leniently, or not at all. Can you see the risk? That cannot be assessed, by the way. It's impossible to assess. It's a pure risk. Pure meaning 100% risk, not less than that. Because you don't know the result of the ruling until the court issues its ruling or the arbitrator issues its award. But you have to make an assessment today, 2 years earlier, or 1.5 years earlier.
Okay. Another question from Mr. Hani Badri. Do you think that time barring provisions can be classified, it means characterized, can be characterized based on type of change? So in optional variations can be executed by others like procurement of specific material, and in unreasonably priced changes, client tried to get work executed for a reasonable price is being obstructed by late notice.
The notice does not include time or money impact. Please read subclause 20.1 first paragraph. The time and cost impact is sent by the contractor with the fully detailed claim 42 days later or 84 days later. Then the engineer evaluates the contractor's application. Then they may negotiate. So the total period will be 4 to 7 months, by the way. I just showed that in the presentation. So the late notice does not result in what you said, because the notice simply in none of the forms in the whole world since they were created includes time and cost impact. There is 2 stages, by the way. There is notification, which is merely an intention that I may submit a claim. And then the fully detailed claim or the detailed particulars in the 4th edition. So the time and cost are first dealt with after 42 days in the 99 edition, after 3 months in the 2017 edition. Then the engineer begins to evaluate, ask for more information, etc. So how can the notice prevent the employer from timely doing the job? But if you ask the engineer to prepare an estimate, which will not be far off the claim if agreed in good faith and by a fair engineer, fair and competent, of course, then this is the best solution to not delay the project. But the Sir Michael Latham report said a very good sentence. I should have included in this presentation. I will include it before I send you the PDF, Dr. Ismail.
Sure.
He says the following in the 1994 very famous Latham report. He says, employers don't know their own mind, so they issue lots of variations. Had the employer decided what he wants during the design period, which is 6 to 8 months or maybe more, had the engineer been competent and did the proper job with, I wouldn't say 0 errors, but with small number of errors, we wouldn't have needed the variation. The variation is for the benefit of the employer, sir, not for the medical contractor. It is the employer who asks for variations, not the contractor. So if the variation are to correct the design, it's up to the employer to choose a competent designer. And if the employer wants to a specific quality of work, he should give good, obvious, clear terms of reference to the engineer. It's not the contractor's fault that variations are issued in the contract, let alone tens. I'm saying I was an arbitrator in a case where there was 263 variations issued to correct the design. Is it the contractor's fault? You want the contractor to be responsible for the design mistakes of the engineer that you employed? This is what I said about collapse of the consulting engineering industry.
Thank you. Another question from Mr. Barakat Qarawi. We have an ongoing project where we have many delay events and we are late to submit a detailed claim within 42 days as required by the contract. What is the best to be done at this moment, especially the client well known that he is using the time barring to reject the claims. So the client is well known to use the time barring provisions to reject the claims. What shall they do?
I'll just correct one of the words. He means he is abusing the time barring provisions.
Yeah.
The 42 days, my colleague, is not time barring. In the 99 edition, it's only the notice requirement that's time barring. But if you read clause 20.1 properly, the 42 days are not time barring unless the employer has changed the clause provisions in the part 2 of the contract and made it time barring. So read the part 2, conditions of particular application, because as is, the 42 days are not time barring.
Okay, another question from...
That's not an opinion. I'm sure of that. It's not an opinion.
Okay. A question from Mr. Mahmoud Suleiman. Does the progress reports even register program updates and the like, which are being reported on a weekly basis to the employer/engineer, can serve as notice or fulfills the purpose of the notice, which is the awareness of the delays, as such reports and data clearly show such delays?
I honestly didn't understand the question. If you can rephrase it or...
No, what is the form of the notice? Is the progress reports that are sent on weekly basis, can these be considered as a notice?
No. By the way, the progress reports, the minutes of meetings, I reserve my right, all these things are not notices. The notice should say simply, for example, let's say, for example, unforeseeable physical conditions, subclause clause 12 in the 4th edition or 412 in the 99 edition. It should go like this. It's 2-3 lines that we have incurred unforeseeable physical conditions pursuant to subclause 12, for example, in the 4th edition. And hereby inform you that we intend to submit a claim for additional cost and time extension pursuant to subclause 44 and 53. That's the notice. So the form is important. By the way, sometimes the form of the notice in common law countries bar the right. So the form is important. but the time period is more important.
Dear Professor Sharif again, now I would say it is the end of your very rich lecture. So there are plenty and endless questions, but unfortunately now time is out. So if you permit me, I will end this distinguished session. And of course, the followers can always still react with you on social media. I'm certain there will be a lot of other questions. We will share with you the video of this event. And if you find in the questions that are on the chat or the question and answers, any question that would merit that you add an additional slide to answer it, we will be very grateful to your good self.
If you give me just 1 minute, Dr. Ismail, just 1 minute.
Sure, sure.
Exactly 1 minute, yani, not more. I'll go to the 99 edition, okay? That's
yes.
the 2 days that my colleague has referred to. Okay, I'll just show it to him, just to see it himself, so that he knows that it's not my opinion. It's the wording. Within 42 days after receiving a claim, that's the 99 red book, by the way, subclause 20.1, not the notice requirement, no, the fully detailed claim. The engineer, sorry, no. Go back. Within 42 days after the contractor became aware or should have become aware of the event or circumstance, or within such other period as may be proposed by the contractor, approved by the engineer. This second sentence means that these are not time barring, because the time is possible to open. For a time to be barring, there must be two conditions. It must be, as a period must be stated, like in subclause 20.1, first paragraph, and it should be expressly stated that time will be barring or right will be lost, like paragraph number 2. But the fully detailed claim, or within such other period as may be proposed, this is not time barring, my friend. Just wanted to show it to him.
But Professor Sharif, what if there is no other such period of time that was proposed by the contractor or approved by the engineer? The 42 days would become a time barring provision or not?
No, no. In order to be time barring, let's memorize this. Two conditions have to apply. First one is, that's subclause 20.1, that there is a period stated, here we are, 28 days. There is a period here stated, 28 days. It's in red now. And the second condition, if the contractor fails, the time shall not be extended, the contractor shall be entitled to additional cost, and the employer shall be discharged from all liability. So these two conditions mean that this is time barring.
Okay.
If both are not, then it's not time barring. So hence, the notice requirement is time barring in the 99 edition and 2017, but the 42 days are not time barring, simply because these two conditions are not provided for, unless, of course, the employer added similar provisions to the 42 days in the part 2. So read part 2 carefully.
Okay.
Thank you.
Professor Sharif, would you like to add anything else, or we can now end this very rich lecture? And I would like to say, on behalf of the Charter Institute of Arbitrators, the Egypt branch, and lecture, and very well attended, breaking all records. So we are very thankful to you, and we hope to host other lectures of yours on other topics. As you know, the topics related to the FIDIC and to the construction contracts are endless, and this one is a very important one, but there are others. So we hope to see you very soon. And I take this opportunity to wish you in advance a happy Ramadan, and also there is also the Easter coming. So for those who will celebrate Easter, happy Easter to them. For those who will be celebrating Ramadan, I'm telling them in advance, we wish you a happy Ramadan. And I would like to thank you very much, Professor Sherif, and hope that we will be able to host you very soon. And as requested by our audience, we will wait for your slides, and we will be sharing them with those who participated to this valuable lecture.
Thank you very much indeed for you, for the Chartered Institute, for the CIArb, for Yahya and Hiba and Shireen. And thank you for the audience and for the questions, which forced me to concentrate for 45 minutes. Thank you.
You're welcome. You're welcome. Thank you very much. Okay, I will say, see you very soon, Professor Sherif.
Inshallah. شكرا دكتور اسماعيل. شكرا.